All right. Good afternoon, everyone. Thanks for attending today's program. On behalf of the DCBA Civil Law and Practice section, I want to welcome everybody who's in attendance on our panel today. We're going to talk about basic Q&A regarding new procedures for the court in the wake of the new coronavirus or novel coronavirus pandemic. We have several of the judges on the call. We have Chief Judge Guerin, we have Judge Paul Fullerton, Judge Robert Kleeman, several of the judges that wanted to also participate, Judge Jim McCluskey, Judge David Schwartz, Judge Jim Morrell, Judge Ken Popejoy, Judge Brian Diamond, and Judge Bonnie Wheaton. We welcome everyone and thank all of them for donating their time to the DCBA to help us learn a little bit more about court procedures as we navigate through all of the changes that have occurred to our way of practice. Few comments at the beginning. Wanted to make the members aware of a new initiative that's been started. The leaderships of the DuPage County Bar Association and the DuPage Bar Foundation were driven by their dedication and passion to each organization's missions to come together for the benefit of our attorney members. And to that end, we are proud to have established the COVID-19 Lawyers Assistance Fund to provide assistance to attorneys in our legal community that are facing dire hardship as a result of income loss or health crises during the pandemic. Grant applications will be reviewed in confidence by a committee, which is comprised of the DCBA President and Executive Director, and the DBF President and President-elect. Our collective goal is to provide funds for basic needs that aren't covered by other relief programs, such as groceries, child expenses, short-term rent, utilities, and the like. If you are struggling, please complete the fund application for prompt consideration. All applications are considered and they are held in confidence. So if you feel you need assistance, please don't hesitate to submit those applications. Our DuPage legal community has a distinguished and laudable history of generosity and contribution to the greater good. If you know a colleague who is struggling, please be the person who brings them hope and share the fund application today. If you're able to further our goal, please consider a donation of any amount to the fund to allow us to help even more members in need. Now, turning to our program today, as I mentioned, Chief Judge Guerin is participating in today's Zoom meeting. He has some opening remarks he'd like to make, and then we will proceed with the general question and answer session led by Judge Kleeman and Judge Fullerton. So with that, I'll turn it over to Chief Judge Guerin.
All right, thank you, Matt. I just wanted to thank the DCBA for initiating these webinars, this one and the ones in the other divisions. They're extremely valuable to the bench and bar so we can explain our policies and procedures going forward and address everyone's questions and concerns. We won't be able to address all of them. It's a work in progress, but I do appreciate the DCBA for your close cooperation with us in trying to get this message out. I want everybody to know that the judges and the staff have been working extremely hard these past few months to try to get business up and running again as close to normal as we can. Our trial court administrator, Suzanne Armstrong, and for these divisions, Judge Kleeman and Judge Fullerton, and the rest of the judges have really put in a lot of time and effort to try to get things moving. These are, as everybody knows, extremely challenging times, but I think together we'll meet the challenge. We're mindful of the need to get business moving. And so with your help, I think we'll move through the turbulent times. We'll get to calmer seas soon. I did want everybody to know the reason we're operating the way we are so far is we are under Supreme Court order that got issued March 17th that stated that we were to hear essential matters and to continue any non-essential matters or to hear non-essential matters remotely when we could. So all the circuits had to determine what essential matters consisted of. And so That's why we've been hearing in custody criminal cases and orders of protection and emergency motions and things like that. But we've always been trying to move toward hearing more what they've termed non-essential matters remotely when we could. So we're hoping that the technology has got us to a point now where we can open up our civil calls on May 18th and start hearing our regular calls as best we can through this combination of technology. I want everybody to understand, though, that this May 18th through June 5th date, the last one that we just did, there is no guarantee that normal operations are going to resume June 8th, that would be, with people streaming into the courthouse. It's still unknown. As you know, watching the news every day, something changes. But this may continue on. So no decision has been made. It's not as if we're just opening the courthouse on June 8th back to normal. But we do have a goal, of course, of resuming normal operations as soon as we can, with everybody's health and safety a major consideration. So I'm working with the other circuits in the Supreme Court. We have what we call COVID leadership meetings every week. Second appellate chief judges meet. I have the chief judge meetings. I have informal conversations. So I'm trying to stay consistent with the other circuits, and we're all trying to move in the same direction. So again, I'll turn it over so you can start getting into the nuts and bolts of this. I agree. Try to read the administrative order. It is all spelled out there. The judges did a great job spelling out the procedures as best they can, but I'll stay here and listen to all the questions and answers. And again, thank you very much for helping us with this.
Thanks very much, Chief Judge Guerin. Along those lines of thanks, I forgot to thank two very important people. That's the DCBA Executive Director, Robert Rupp, who's also participating, and Barb Mandrala, who have been instrumental in putting together these Zoom webinar programs for our members. The programs themselves are recorded. They will be posted on the DCBA's website. I understand that the family law section that had their webinar yesterday already has the program from yesterday up on the website. Today's program will be up by tomorrow morning as well. Now, in terms of Q&A, a lot of the questions that I had received over the past few days leading up to this program were questions that could be answered through a review of the administrative orders, but there are some things that we just can't glean from the face of those documents, from the administrative orders or from any of the amendments. So here to tell us about different procedural avenues that we need to take as civil practitioners, we have the presiding judge of Chancery, Judge Paul Fullerton. We have the presiding judge of the Law Division, Judge Bob Kleeman, and they will be here to kind of lead us through the Q&A session about new procedures for the 18th Judicial Circuit Court. As we move forward through the program, if people have questions, they can submit them, and we'll try and interpose those questions to the panel. But for now, we'd like to turn it over to Judge Fullerton and Judge Kleeman to walk us through the beginning of the Q&A.
Okay, I guess I'll start. Thank you, Matt. Real quickly, to emphasize what Judge Guerin was just saying is the administrative order that came out on Friday, May 1st. If it's important, it's a long order. It's 13 pages, but it covers everything. As far as what we're trying to do in this courthouse from May 18th through at least June 5th. And the overall thing we're trying to do is get back to hearing cases. A couple weeks prior to this, I know that anything that was not a general status, which were automatically continued, we've tried to hear those cases. And in our division, I know that the judges are either issuing written rulings or at least addressing those cases that were other than general status cases. This new order of May 1st, on page 3 of that order, there's a whole section on remote proceedings, and that's really what this is all about. And then the Chancery, there's a whole section for the Chancery division, there's a whole section for the law division. And if everybody has the opportunity or should read those, take the time to read it, because the procedure is actually, it's pretty well detailed. The only other thing I want to say is in order to start with status hearings on May 18th via Zoom or court call or some remote type procedure, what we're encouraging, at least in the Chancery, and I know law division's doing this too, we're encouraging the attorneys to talk to each other prior to their status hearings. And if they can reach an agreed order, that would be most beneficial, because we all know that most status hearings are attorneys coming before the court, telling us what the status is, and we're entering an order for a future date. I think a lot of that can be resolved if the attorneys pick up the phone, talk to each other, and come up to an agreement, and then submit the agreed order prior to the status hearing. You'll get your date, and then we can deal in a Zoom fashion or a remote fashion, Zoom or court call, with matters that there's either no agreement or something else is at issue. And I think that would be most helpful. So with those introductory comments, I'll turn it over to Judge Kleeman, and then we could take questions.
Thank you. I really don't have a lot to add. Paul and I have tried to work in concert to make our administrative orders as similar as possible, to make them as user-friendly as we could. And I can't stress enough what he just said about making sure that you make an effort on these status calls to see if you can't reach agreement and get those submitted in advance. Beyond that, the purpose of this is to try to get as much work as we can, to get as close to normal as we can in the weeks ahead, and also to begin preparing if we have limited physical access to the courthouse after that. So we're getting as much work done as we can. And we appreciate all of your help and cooperation during this challenging time, but I would echo what Judge Fullerton had to say.
All right. With that, we do have some questions. Again, some of these are going to be specific. Some of these are going to be general for the entire civil division, Chancery and law. But we will try and get through as many of these questions as we can. And I will start with a question from attorney named Jeff. Jeff says, how do you want agreed orders to be submitted? And I guess I'll leave that open to the presidings because there's some courtrooms that have electronic order access. There's some that don't. How do you want the attorneys to submit agreed orders to the court?
Currently, we're asking that they be submitted to the judge's administrative assistants. We have in the law division, up until recently, only one judge had electronic orders in use. That was Judge French. We've made arrangements with the help of the Chief Judge's Office. All of the judges in the law division now have electronic orders available. We're making arrangements to make sure that they're all available. So beginning May 18th, I expect we'll be able to accept them via electronic orders, but I haven't been using those for a while. But in the meantime, the administrative assistance is the way to go. But beginning May 18th, our hope is that electronic orders would be the universal ability of all of the judges.
And to echo that, Matt, in the Chancery division, everybody's equipped with electronic orders. And we've been doing them for a while. So we would like that. If for some reason a written order needs to be done, you know, they could send that to the administrative assistant. We could get it signed and get it entered.
Yeah. And I'll say this personally, I've only had to contact the reception areas a couple of times, one for Chancery and one for law. And both of the chambers clerks that I dealt with were very helpful. They understand there's a lot of stress going on with attorneys not knowing procedurally how to handle things. I spoke with a couple of folks who we walked through the administrative order together, and then the person told me how to go about submitting something so that I made sure the judge got it. Both very helpful. Well, you know, we don't want necessarily to flood calls to chambers, but in the event that you really can't understand portions of the administrative order, you want some clarification, they have been very helpful. What do attorneys do if they have cases scheduled in more than one courtroom at the same time? And I'll just toss that out to the entire panel. What would you like to have the attorneys do in the event that they find out they're scheduled for more than one courtroom at the same time for Zoom meetings, Zoom hearings?
I'll take it first. I mean, we would accommodate as long as we know in advance. You know, obviously you can't be in 2 Zoom hearings at the same time, but if they let us know, then maybe we can talk to the judge in the other courtroom and see what we can do. Maybe accept an agreed order in one case or something like that. You know, it's a great question and it's going to happen. And we're just going to try and accommodate in some fashion.
One thing I would follow up, I agree with all of that, but with the Zoom hearings, the administrative order in each of our divisions indicates that you have to request those a week in advance. And there's a reason for that, so that we can schedule. If we get multiple Zoom requests on a 9 o'clock call, we may have to space those out. So if you want a Zoom hearing, you have to let us know in advance. And if there's a conflict, we should accomplish that, or be able to accommodate that, I guess I should say. And if it's a conflict that you're doing regarding court call, as Judge Fullerton just said, let us know in advance, check in with court call. We're going to do our best to accommodate those sorts of situations, but just give us a little heads up and we'll do our best.
Right.
Okay. For courtesy copies, there were a few questions about courtesy copies, and I think that's fairly spelled out in the administrative order that we can email, the attorneys can email courtesy copies to the court through designated email addresses for the particular judge. If there are requirements that a particular judge has beyond certain things that are contained in the court file, or things that the attorneys want to submit to the court for additional consideration, how should those items be submitted? Should those be submitted via separate email also, or will the judges not consider anything outside of what's in the court record?
On behalf of the law division, we want everything sent via email to the extent it's possible. I think the reasons for that are fairly obvious. We want to avoid people coming to the courthouse if we can do it. If you think you need to send something that's not covered by the administrative order, I would urge you to send an email and see if the judge requires that. I'd like to see everything that needs to come in via email as opposed to any other fashion. I don't know if that's the thrust of the question, but beyond that, as to each individual judges has a specific requirement, I'd leave that up to him or her. But how he gets courtesy copies, email is the answer from our end.
Okay, yeah, and I think the concern from the person who posed the question was, not sending too much to the court so that the court would just, not consider something or set it aside because it wasn't something that was, part of what typically goes with the documentation. Like if there's a motion, a response, a reply, and whoever submitted the motion wanted to present other things along with the briefs on the motion, is that okay to submit other things with it?
Yeah, again, I'll turn it over to Paul in just a second. If it's by email, I think it'll be fine. The problem we've had in the past is when somebody has literally hundreds and hundreds of pages sent via email, that can be a bit of a problem, but we'll take that on a case-by-case basis. If you send it via email and that poses a problem, we'll do our best to let you know in advance. I think it'll be fine. I don't know if that answers the question, but that's what your thoughts are, Paul.
Yeah, I would agree with that. I mean, generally though, if somebody has a contested motion, you've got the motion, you've got a response brief, you have a reply brief. If they're looking to we're trying to set these things up just like we're in court, only we're remote. If somebody were to come before me and I've got a full set of courtesy copies and now they want to hand me something new or different in addition, I'm sure the other side would be objecting to that. But I echo what Bob just said, is that, communicate. I think communication can solve many problems. So communicate prior to the hearing, say that you want something extra to be brought before the court, send it via email. In ours, I think in both law and Chancery, we specifically say all courtesy copies are now coming via email. And again, the reason for that is pretty obvious.
And bear in mind that most of the judges have access to the duct system on their iPads or computers at home so that, if there are extensive exhibits attached, we have access to those. When I'm reading a motion to dismiss, I always go on Ducks at home and read the underlying pleadings.
Yeah, that's an excellent point. We have our computers now through, the IT department here in the courthouse has set up our computers. Our laptops on the bench are just like that we take home now, are just like we're in the courtroom. So we have full access to Ducks and everything else.
Okay. Yeah, this is all really helpful information. I'm even learning as we go along too, some of the things that I'll need to be doing as a practitioner.
I would I'd add one comment on that. Since there still should never be any ex parte communication with the judge, anything that's sent to the judge should be copied. There should also be an email to the other counsel or other parties. And I think if you're going to send something, I mean, I could foresee where there would be a situation, let's say a person passes away and you wanted to send the death certificate. It occurred after the briefing because that's important, obviously. I think it'd be a good idea in the email that sends the courtesy copies or in a separate email to highlight this is not part of the court record, but it's pertinent. And so basically it's a heads up to everybody that this is attempting to be submitted, but it's not yet in the court file.
Okay. Okay. I have a question from Lisa Bradley at Cadillus and Associates, who is asking a number of questions, but a couple of them I found to be kind of important for the attorneys to know going forward. Will the Zoom hearings be recorded? And if so, can that recording be used for purposes of a transcript, a report of proceedings?
Let me, I'll address that because we just had long conversations on this with the court reporters. So yes, the short answer is yes. And as the judge, as the host of all Zoom hearings, there's a record button at the bottom and the judge is required to hit that record button and record everything. Now, on some Zoom hearings, you're going to have a court reporter in one of the boxes like we have here, in one of the Hollywood Squares boxes that we referenced. But for the status hearings that we're going to be starting up on May 18th, there are not enough court reporters to be in every courtroom, so to speak, or in every Zoom hearing. So what is going to happen is every Zoom hearing that a judge has is going to be recorded. Our court reporters have the capability to take those recordings, put them into CourtSmart, and they are going to be the official record. So if you're having a Zoom hearing and attorneys bring their own court reporter, that's fine, but that's not the official record. Just so I was told that today or yesterday, I believe, with our court reporters. And I think I'm going to ask Chief Judge Guerin to make sure I'm correct in what I'm saying, or he'll tell me I'm not.
Correct. The judges should be conducting these hearings. Oh, wait a minute. Am I muted?
Oh, you're good.
Oh, in their courtrooms, because that's the way it's hooked up with CourtSmart. So the anticipation will be the judges will physically be in the courtroom doing the Zoom hearings so that the court reporters can get a hold of it and record it.
Okay.
But the process is when the judge, as soon as the judge is hosting, as soon as he starts Zoom, there's the record button at the bottom,
Right.
and we re-record it.
Okay, and then the official court reporter would operate off of that recording?
Yeah.
Correct.
Gotcha.
And nobody else is allowed to record it. That's in the administrative order.
Okay.
Right.
Okay.
We actually, to follow up on that, Matt, we have I don't want to call it a script, but it's an outline for judges when they're doing Zoom. There are certain things we need to tell everybody before we start the Zoom hearing. And one of those things is that, number one, this is going to be recorded and this will be the official court reporting. And number two, is that nobody is to record any of these Zoom hearings outside of the court's recording.
Okay. I have a couple more questions from Lisa, and I chose these because they seem to apply to all different divisions of the second floor. Will scheduling for Zoom court proceedings be different from our traditional method of scheduling the hearing through chambers, and if so, how? So when I would have to file a motion, I would call chambers, I would try and get a hearing date and time, and then I would prepare my notice and then file that with the court and serve the other attorney. Is it going to be different in terms of scheduling a motion for presentation or scheduling any type of hearing, different from that process than we're used to doing?
Well, in terms of, I think the Chancery administrative order is pretty similar to the law division order, but it's spelled out there. If you want to get a hearing date, you contact the judge's secretary, just like you would in times past if it's not addressed at one of the status hearings that you do appear on remotely. But if you're requesting oral argument, again, I urge everybody to take a look at that. That request has to be made in a week, at least a week in advance of the hearing date. So that is a little bit different because obviously some of these are going to get decided on the pleadings, and some of these are going to get decided using oral argument done remotely. And again, in terms of presenting new motions, they can be filed with the clerk and emailed to the judge's secretary. The administrative order, and I believe the Chancery one is substantially similar. We urge the parties to get together and get a briefing schedule. And when we know that there's a reply brief, I'm directing our administrative assistants to send out requests, trying to set a hearing date as soon as we have that in hand. So again, to echo what Paul said early on, I'd urge everybody to pick up the phone, talk to opposing counsel, let's see how much of this we can get worked out. But the short answer to the question is yes, to the extent you schedule those through the administrative assistant in the law division.
Okay. And to piggyback off of that question, does the court have any suggestions as to the format for giving notice of Zoom hearings? Is there special language that the attorney should be using to notify the other side that that there's something different in terms of this hearing? Should we state that login information will be provided at a future date for remote hearings? Is there something in particular that the court's looking for the attorneys to provide in terms of notice to the other side?
I am not. I'm just looking for you to let us know at least a week in advance, and I can't stress that enough because we expect we're going to have some scheduling difficulties that we hadn't had before. So if you want oral argument on one of these, let us know a week in advance. And if you want it to proceed via Zoom, I don't need any special language. Just let us know that. We hope to have the ability to do court call contested hearings as well. But just let us know. I don't have any special language from our end.
Oh, I agree. I don't have any special language. If you want to put in your notice of motion that you're requesting it via Zoom, that's fine. I'm not going to make that any kind of requirement.
Okay. I have a question that came in from Colleen McLaughlin. She asked, or she wrote, I'm not sure I'm understanding the email system being set up. In federal court, we submit proposed orders to a proposed order email address for each judge. So it's not formally part of the record until the judge signs it. And there's no question that the communication to the judge is not part of the record. Is that going to be the case here in the 18th Judicial Circuit? Or is anything that's sent to the email address that you're setting up for each judge automatically going to become part of the record?
It would not automatically become part of the record. The email sent to the judge with a proposed agreed order would not become part of the record unless there was some unusual reason to do so.
Yeah, my understanding is if we submit proposed orders to the judge's email addresses, it's just that it's a proposal and nothing is part of the record unless and until the judge signs it. Is that correct?
Yes.
Okay.
Yes.
The procedure is going to be a little bit different if we're using electronic orders. Then they would just upload their proposed order through that system, and they wouldn't have to email them to the judges at all.
That's true.
And that's again, that's an excellent point and highly encouraged. It expedites things and makes them simpler.
I have a question from Pat Edgerton. He writes, not all cases have attorneys for all parties, but instead have pro se litigants. Likewise, sometimes difficult to contact some attorneys prior to status dates is experienced. Many times, given the posture of the cases and knowing the judges, we generally know what usually and customarily would happen in court. Can we submit a proposed order prior to the court date and time that's scheduled, explaining the current status to the judge and setting forth a proposed order at the same time copying opposing attorneys or pro se litigants?
Yeah, the answer to that, and I've had this question come up, you can certainly submit the order letting us know what the circumstances are and that it may not be an agreed order because of the circumstances. And the assigned judge, we'll get that to the assigned judge and he or she will consider it. I can't tell you whether it'll be entered or not. That depends on a variety of circumstances. With respect to the unrepresented litigants that was touched on, we are trying to address that, and I don't want to get too far ahead of ourselves because I know as of yesterday, we were still looking at some language, but in the law division, and my understanding is Chancery as well, the chief judge's office is preparing a notice to them, informing them that the case is scheduled to proceed, and here are your options as to how to proceed. I don't know that we have final language on that, but that's hopefully going to go out in the very near future, so that they're aware the case is up and they're at least given the opportunity to participate if they wish. But again, that's a challenging issue we're going to continue to have to work on.
We had a question come in, and it was in the context of small claims cases, because I think for the most part in civil cases, that tends to be the majority of pro se litigants. But I think it applies to all of the different divisions. How will trials and hearings work with pro se litigants from a technological standpoint? In other words, how will the pro se litigants know how to participate in Zoom proceedings? Will the pro se litigants have the capability to do this? Will the court give some leniency to pro se litigants because of technological difficulties? How will we address the pro se litigant population?
Well, in small claims, as you touched on, that is, I expect to be a challenge that we're going to have to deal with. The notice that we're contemplating sending out gives them the option of doing Zoom, which may not be a practical one. It does give them court call, and our court administrator informs me that court call we're expecting that to be, the fee for that to be waivable for self-represented litigants with judicial approval. And beyond that, like I said, I know those won't solve all the problems, and I'd love to tell you I have a clear picture as to how all this is going to work out. But we are going to send out notice telling them how they can participate if they choose to do so. Court call should be available at no cost. They may have to do some steps to get in. We'll take that one at a time, and we'll just have to do the best we can. But we are supposed to send out that notice hopefully within a day or so.
Yeah, Judge Kleeman, I finalized that language late yesterday.
Okay.
So that should be going out. I'll check again with the clerk's office, but it should be going out explaining how self-represented litigants can access the courts with this technology. I don't believe, unless I'm incorrect, that we're contemplating trials being conducted this way.
Well, no, I can't. Yeah. That hasn't been addressed yet, and the issue of how we're going to conduct trials, or to the extent there are evidentiary hearings, we haven't really addressed. I had a Zoom conference today where they're contemplating a bench trial, and I've cautioned them that it's going to take a little planning and things like that for bringing in people to courthouse. But no, at this point in time, conducting trials has not been, via remote technology, has not been addressed.
And I believe if the self-represented litigant cannot or is unable to access the proceeding with the technology, then it's contemplated, is it not, that there'll be another date given?
Yeah, we had some discussion about that, but yeah, it's difficult to imagine a time when you wouldn't be accommodating given the emergency proclamation and the shutdown order. But yeah, I would expect everybody would be accommodating of that.
Yeah, and just to follow up a bit on that, this what we're talking about now is for basically May 18th through June 5th, and there's, in Chancery at least, and I think in law too, there's going to be we're not going to have evidentiary hearings, or definitely no trials. So what we're talking about is getting statuses moved, cases moved along, and also any hearings we can do. But I don't think we're at the evidentiary hearing stage yet in the technology world. One step at a time.
I agree with that.
We have a question that came in from member Ed Tsinga. He asked, will you require hyperlinks in long PDF documents? There's another county that requires that. It seems like a good idea, but is it required now, and will it be required at some point in the future? And he gives the example that there would be, if there's a long PDF, there would be a hyperlink within the body of that document. That would be a reference to an exhibit, and then once you click on that, it'll go right to the cited portion of that exhibit. So if there's a 40-page lease and you click on that hyperlink, it'll take you right to the provision that's being cited. I was hesitant to ask this because it creates more work for the attorneys, but if it makes the judges' lives easier, I thought it would be interesting to pose that question to the panel. Do you see hyperlinks within PDF documents becoming something that we'll need to be concerned about?
It sounds like an excellent idea. There's no requirement at this point in time. And frankly, I'd have to look at it a little further before I considered recommending that be a requirement. But it does sound like a good idea. It is not currently a requirement.
If attorneys use hyperlinks, will that be frowned upon?
I'm okay with it. I mean, anybody in Chancery, I think it's beneficial.
Yeah.
But I agree with Judge Kleeman, making it a requirement. We're far away from that right now.
We're still trying to figure out how to get documents visible to everybody in a Zoom hearing. Hyperlinks is a little farther out.
Yeah.
Yeah, like Judge said, baby steps, right?
Yeah.
Peter Paputz has written a question. He says, when the shutdown occurred, a few dismissals for want of prosecution were entered on some cases. Will the court on its own enter orders vacating those DWPs? And will the fees for filing motions to vacate those DWPs be reimbursed?
I'm not going to comment on any specific ruling that would be made. So whether they'd be waived or not, that's up to each individual judge to look at the circumstances. And if you want to have one of those vacated, I would urge you to file the motion to vacate it, because I'm not aware of what mechanism would bring that to the judge's attention necessarily. But beyond that, I'd be hesitant to give a specific answers to how a judge would handle a motion to waive the fees or what have you. But bring that motion.
Case-by-case basis?
That's correct.
I agree 100% with what Bob just said.
Member named Daniel Chaidez wrote, are the courtrooms equipped or going to be equipped with technology to allow for trials, specifically jury trials, to be conducted remotely?
I'm not aware of any plans to that end at this point in time.
Yeah, way too early for that.
Okay.
I mean, the current administrative order says all jury trials in the civil world are continued, I forget the date, August, something like that.
August 24th.
Thank you, August 24th. So that to me is a long way away.
It is.
We'll see what happens.
Elizabeth McKillop wrote a question. For fully briefed contested matters that will be ruled on without oral argument, should we be submitting a proposed order or proposed future date, or should we just wait for the ruling of the court and then deal with the order afterward?
The ones I've done, I have either drafted the order myself, or if I want the attorneys to draft an order, I will advise them of that. So generally, the ones that are done without oral argument, on every instance I've done, I've drafted the order. But I think that's a question each judge would handle separately, I would assume. But I don't know what your thoughts are. The ones without hearing, I've drafted the orders.
I would agree with that. I've entered a number of rulings already, and I agree with Bob. I'll either draft the order, or if I need the attorneys to draft the order, I'll let them know. But submitting a proposed order on a contested hearing, I don't think we need that. But again, I would let each judge handle it their way.
On the hearings that I've had without the arguments of counsel, I prepared the orders, and if I've entered a final order, I have sent at least notice that I've entered a final order so that they would be aware of it. I think the prior administrative order said the attorneys are responsible for following their own cases, but I think it's only fair to the attorneys just to notify them that a final order has been entered so they don't blow any statutes or appeal time.
Okay. I know we've had a number of folks who work in the probate division quite a bit, submitting some very specific questions. I think some of those are better addressed individually outside of this program. But there are a couple that I think folks would want to know that are kind of broader questions and might be helpful to the entire group of the several hundred people attending. So I will put Judge Gibson on the spot and ask a couple of questions just specifically as to the probate division. If we are still doing virtual court appearances after July 1st, how will orders of discharge be handled in closing estates? These currently are the only types of orders that are not electronically entered in the courtroom, but rather a paper handed up to the judge.
That's actually Judge Diamond.
Judge Diamond, yeah.
Judge Diamond. Oh, Robert, can you unmute him? There we go.
A couple of things. There'll be procedures to continue. Actually, I put on my courtroom on the county, the circuit court website, new procedures, temporary procedures for this COVID-19 emergency. And they will take the attorney through the steps to have things closed or continued. A case such as that, where the status is going to be continued, I simply, in a short order, require that they submit an order explaining what needs to be done between now and the closing of the case, and then puts the case off. Usually I'll do that for a year, and then if things are wrapped up in the interim, they can put the case back on the call to close it. So there are specific procedures, temporary emergency procedures that are outlined for Courtroom 2011, the decedent's estate procedures for opening and closing estates and other matters. And a lot of that stuff I have been doing right since the courthouse, since March 17th when this all started. So cases are being opened and closed every day in 2011, simply allowing me to review documents and then communicate through my legal assistant with the attorneys as to additional things that might be required on a specific case.
Okay, and you said that could be found on the website? On the
circuit clerk, on the 18th Judicial Court website. If you go to room 2011, there's a PDF document there that'll explain how to do those things. And any other questions can be directed to the legal assistant, but I think it's pretty self-explanatory.
Okay, perfect. I received a question from Attorney Tim McLean. He asked, as to the arbitration division, what will happen with arbitration hearings scheduled after May 15th? There's one that he has currently scheduled for June 3rd, and he wants to know whether that date will stand or whether it will be postponed by an order on the court's own motion. And I bring this up because he has a specific question, but I think a lot of people who have things scheduled would like to know, can they expect that hearings, arbitration hearings that are scheduled for June and July dates are going to go forward on those dates? Or can we expect that if they need to push back, the court will notify the attorneys and the parties accordingly?
They will not be proceeding. And
Okay.
On page 11 of the administrative order and under the law division specifically, it's subsection F, all currently scheduled arbitration hearings will be continued. If they don't have a future date, and I think they all should have a future date in their assigned courtrooms after the scheduled arbitration hearing, they will be given one. But at this point in time, any arbitration hearing that's currently scheduled will be continued.
Okay. As far as post-judgment proceedings are concerned, we had a question, how will citations to discover assets proceed with the current court operations? Will they proceed in the same manner as in the past? Is there something specific that the court would like us to do or not do with respect to supplementary proceedings?
Well, I don't recall if it's addressed in the preliminary portions of the administrative order, but with respect to judgment proceedings, at this point in time, we are governed by the governor's executive order and the Supreme Court rule following that many of those in consumer cases are suspended. So if you're not aware of that, I point everyone's attention to taking a look at that. Both the governor and then the Supreme Court came out with some specifics covering a great deal of those. And obviously, we're going to honor those directives. But beyond that, no, if there's something that's not covered by those, I don't have any special requirements or any other special rules, but I would urge everyone, if you haven't, to review those orders from the Supreme Court and the governor's office.
Okay, I have, let's see. A question from member Edward Sherman. How will the Zoom hearings work in terms of dialing in? Does the court send out the Zoom notice to click on a link and participate in the hearing? Are we expected to do something on our own to dial into the Zoom hearings? How will, just procedurally, will the Zoom hearings work once they're scheduled?
Once they're, well, to echo again what Bob had said a couple of times, is there needs to be a request to have a Zoom hearing at least 7 days prior to. And then once that request comes in, I'll go right to the Chancery order. It's pretty specific too. Basically, the request, the request must include all parties' email addresses, case number, and caption, and must be made to the judge's secretary. Once that request comes in, the judge and/or secretary will send out the Zoom invitation. So then the attorneys will have it on an email, and then it'll have the date, the time, case number, and all they have to do is get on their email, laptop, whatever device they're using, and click in and link in, and they should be accepted into the Zoom hearing.
And again, as we go throughout this Q&A, it's been said before, but I'll stress it again. It's a very lengthy administrative order, the most recent one that came out. It does contain a lot of the information that I'm seeing questions come in on. It's a long read, but I think a lot of us have nothing but time right now. So take the time to look at the administrative order, look for your specific sections of civil practice. It's very detailed, and a lot of work went into it, and we don't want that work to be for naught. So to everybody attending, please review the administrative order, because it does lay out a lot of the procedural groundwork for the attorneys to follow. And
on page 3 of that order, just almost the entire page is just devoted to remote proceedings. And it's very detailed, as you just said, Matt. And if the point I'm trying to make, even though this is a 13-page order, no page 3 about remote proceedings, and then go to Chancery on whatever page that's on. And that's, that's only a page and a half, roughly 2 pages. And then the law division section is another 2 pages, but they're kind of repetitive. So even though the order is a 13-page order, you go to those sections that talk about remote hearings, and it should cover everything that they need to know. We are in uncharted waters, so.
Also, Judge Fullerton, if they'd read the whereases, because I spent a lot of time on those.
Right. Those are always the best.
Yeah.
I got a question that came in from John Chitkowski. He wrote, in the event settlement conferences or pretrial conferences are conducted via Zoom during this period of time, I'm assuming those will not be recorded. Is there any way the court can confirm whether or not settlement conferences or pretrial conference done with the court would be recorded?
Settlement conferences would not be recorded. They're not on the record unless there's a request to do that. In the law division, they would not be recorded. If it's a settlement conference, as opposed to a final trial conference getting ready for the trial the following week, which is not an issue, but settlement conferences would not be recorded.
And there are capabilities now for the court to do what we would do in if we were live in person, to separate us in different areas of the Zoom conference so that the other side couldn't see what one side is doing?
There are. I have not done a settlement conference via Zoom yet, but yes, the short answer to your question is yes, that capability exists.
Those are called breakout rooms.
Yeah, the breakouts or the caucuses is if there's a way that is able to be done, I would assume that the litigants and the attorneys in the court would work out ahead of time logistically how that's going to be conducted.
Well, Judge Gibson had I don't want to speak for Bob. I'll let you talk about it, but Bob did it. So go ahead, Bob.
Hearing, and we did utilize the breakout room between the public defender and the respondent. Well, in actuality, we did a practice run where we used the breakout room, and then ultimately the respondent chose not to appear at the hearing, so we didn't need to use it. But there is the capability, and the judge monitors that, and the judge can do several things, can limit the time of the breakout so that it ends at a certain point, can make an announcement to the people in the breakout room and call them back in. So there's ways to do that. And of course, in the main session, anybody requesting to be broken out, so to speak, they'd make that request and the judge would decide that.
Okay.
Actually, I actually have a question. Was the question before about settlement conferences?
Yes.
Because,
yes.
And I don't know, in the administrative order in the Chancery division, page 8 on subparagraph G, it says all settlement conferences may proceed via Zoom video conference, court call, or continued at the discretion of the judge.
Right.
Is that, and in law division, it says similar.
Right.
Settlement conferences may proceed by Zoom. So is that different from what was just said? Or?
No,
Well, I'm sorry, Bob, go ahead.
All right, you go.
The question was whether the settlement conferences would be recorded. And the answer is no. I want to stress that what we're doing remotely is similar to what we do in the courtroom, only nobody's here. Everybody's in a different location. So a settlement conference is never on the record. So the attorneys go back into the chambers and we have a settlement conference. And if somebody wants to go on the record, we come back in the courtroom and go on the record. I think the question was, will settlement conferences be recorded?
Oh, okay.
Bob indicated, no, we won't be hitting the record button on Zoom. But we have that capability similar to a regular settlement conference. You have a settlement conference, it's not on the record. And then if somebody wants to go back in the court, if we were here, we'd go back in the courtroom, go on the record. If somebody does want to go on the record, for some reason at the conclusion of the settlement conference, we're able to record that and make it, quote, on the record.
I see. I misunderstood. Thank you.
Sure.
Kevin McQuillan asked a question about service of process. Will the judges grant leniency for service of process issues due to the difficulty of both getting someone to be able to serve the process and then also because of defendants sheltering in place? I think there's some concerns about diligence issues. Can the court address those concerns?
And I understand those. The only hesitation I have is, again, I don't want to get in a situation where I'm telling somebody this is how we will rule under these circumstances. Certainly all the judges are well aware of those challenges. But again, I can't bring myself to tell you this is what will happen under certain circumstances. I don't think that would be appropriate, but certainly bring that information to a judge, and I'm certain he or she would give it serious consideration. But beyond that, I just think prudence dictates that I not give a specific answer to that question.
It's another case-by-case basis, correct?
Yeah, agreed.
Are there limitations to the types of civil cases or matters that will have Zoom hearings as an available option? And if so, how will a specific civil case or matter qualify for a Zoom hearing?
Well, the one thing I can say is that Judge McCluskey's courtroom, which is 90% evictions, they're not going to be going via Zoom. And that's why that court call has been basically continued and continued. And when people finally start coming back into the courthouse, Judge McCluskey's going to be working very, very hard, I think. But part of Judge Gibson's call, the guardianships, and I can let Bob speak to that, but generally they're not going to be subject to Zoom. I would think everything else in the Chancery division could be subject to a Zoom hearing.
Yes, the nature of the guardianship hearings, you run into a lot of issues, one of which is the service issue, because if it's an adult guardianship, the respondent has to be served with process. Oftentimes they may be in a medical facility or assisted living or nursing facility. So even getting service would be an issue, and due process suggests there has to be service on a respondent before they're declared disabled and awarded the court. So those matters, and there's also the requirements that certain family members be given mailed notice. And then oftentimes the respondent or the other family members would show up in court, and they may not have counsel. Probably the majority of the time they don't have counsel. And so to try to have those proceedings with those problems, to attempt to have them by Zoom with pro se litigants and with the issues of service, it's just not feasible. Now, there may be emergencies, and there have been emergencies that for a sliver or a slice of the relief to address an extreme emergency situation, that can be done pursuant to the administrative order. But in general, plenary guardianships that are at the outset will not be able to proceed for the time being.
Somebody else just sent in a question that said, will there be a follow-up to this judge's panel in 30 days or so to reevaluate the procedures, what's working, what's not working? I think everybody's finding these Q&As helpful, and I think they want some assurance that the court will be accessible. I think I have no problem saying, of course, the court's going to be willing to provide further information as it comes up, and provide further feedback to the attorneys and pro se litigants. But would you be up for all of you participating in something like this maybe a month or two down the road again, just to see what's working and what's not, and what the court would like to change and have operate procedurally different?
Yes.
Yeah, absolutely. Again, what we're operating on is May 18th through June 5th, and we're going to see how this goes and how well it works. And I think we'd be open to whatever down the road.
A timely question came in on that particular subject. If court is open up and resuming back to normal with people coming in for court hearings in person, if there's folks that are concerned about appearing in court because of health issues or health concerns, they don't feel safe coming to the courthouse, will the court still be amenable to those attorneys or pro se litigants participating in those hearings via Zoom? Or once the court opens back up, it's kind of that's what you have to go back to, is the live hearings in person?
Well, I would think that, again, it's a case-by-case basis, but the chief has said this a number of times, and I think it bears repeating that safety's first. And if somebody's got a serious concern, we'll accommodate that. We'll have to take it as it goes, but there's a number of means by which people can participate, and the safety of everyone involved, courthouse staff, the litigants, the lawyers, is the first thing. So if you need to make that request, make the request, and I promise it will be given appropriate consideration.
Okay, I see that we've hit 1 o'clock. If the judges don't mind, we just have a few more questions. If we could go through those.
Sure.
Can I make a comment first?
Sure.
For some reason, all of the Chancery and Law Division calls on June 1st are horrendous. They're 50, 60, 70 cases. So if anybody in the audience has a case on June 1st, I suggest that you immediately call your opposing counsel and see if you can get an agreed order, or call the secretary in the division and get the case continued to another date. It's going to be chaos otherwise.
Matt, I wanted to mention something also as to participating in a hearing when you have when you're concerned about medically appearing in the courthouse. We have court call. So anybody, and this has been in effect, at least in the Chancery Division, I assume in the Law Division as well, anybody can call in, provided the court, and I think we're all going to be outfitted with court call, before the June dates. But if people are worried about appearing in court for medical reasons, they can always use court call and appear by audio. Zoom might be difficult to set up, but certainly court call is always there. And as I understand from somebody mentioned earlier, that if they're pro se's, they may be able to appear without cost.
And that's a really good point, Judge Diamond. Is court call's been around for a lot longer than our Zoom proceedings have. So if anybody does feel unsafe, court call is a smart way to go. I appreciate that. Henry Cass has submitted a question. He specifically asked, how should we handle default prove-ups in adoption matters? But I think I'll broaden that a little bit also and say, how do we handle prove-ups just generally for civil cases? Is there some specific procedure that each of the particular judges would like to utilize, or is it kind of across the board? It's going to be handled, default procedures are going to be handled the same way across the board through all the different courtrooms?
Well, on the adoption, there's, again, Judge Kleeman was talking about case-specific situations, and there's the situation where, for instance, there's a biological father who was served with process, and let's say could reside in state but might reside out of state, and they haven't filed an appearance or a pleading, but they intended to physically show up in court. In that situation, I'd probably be hesitant to enter any type of default order. But like any other situation in the law, there may be reasons to be able to do that. Depending on the specificities of that case. So I would say that it's going to be case by case. If they're seeking to have a default order entered, they would have it on the court call. They would, they'd submit an order, and then it would be evaluated whether it should enter or whether it should be put over.
Okay, thank you very much.
In my courtroom, I would, depending on the circumstances, I would certainly be amenable to accepting an affidavit in lieu of live testimony.
Okay. And for those that haven't already seen the administrative order that we've been talking about today, you can find that administrative order, which is 20-20, at www.dcba.org/COVID update. And that that link is continuously updated so that we have the most recent information available to our members. You can check it out any given day, and there may be more new information, amendment to the order, what have you. That's constantly updated by the DCBA staff. So if you want to have quick access to that order, feel free to go onto the DCBA's website and go to dcba.org/COVID update, and you'll find the most recent procedural information for the court. We do have a couple more questions, and then I think that a lot of the other questions that I've been receiving are things that can be addressed by that administrative order once the program is over. Let's see. There was a question specifically about foreclosures and evictions. And a member wrote that the Illinois Supreme Court previously issued a directive to the circuit courts to not enter any judgments of foreclosure or eviction orders. If so, when will that be lifted? This is not particularly my area, so I'll leave it up to the judges. Is there some sort of stay on eviction and foreclosure cases?
And once again, it's in the administrative order. It's May 18th for the foreclosures. I'll let Jim talk about the evictions.
But it won't be lifted by then, right? It'll just be evaluated.
There are no I'm going on the last order that just says no foreclosures until May 18th.
Right, and I think the concern for some of our members is that, you know, automatically everything starts running again, but that could be amended before May 18th, correct?
Anything's possible. Certainly, if things have not been briefed on foreclosures, for example, if someone's worried about a summary judgment or some sort of motion for default, I don't think anything is going to happen immediately on the 18th, but that's when we'll open up hearings on that date. So if people need time to respond, again, a case-by-case basis. I have signed some orders on agreed orders extending briefings, changing hearing dates already. So again, if anyone has agreed orders, please send them and I'll sign them out.
Okay.
And why don't we let Jim McCluskey, if you have anything to say about with respect to forcibles, real quickly.
Yeah, that's by the page 8 of the order. I think it's subparagraph H. All of the forcible cases have been continued to Monday, June 8th. And if they're federally funded cases, in other words, if any of the financing on the landlord's part or FHA housing or Section 8 housing, you can't start an eviction until July 25th. And that's by the CARES Act. And that does not occur until there's a 30-day notice has to be sent out outside the court system before they can initiate an eviction lawsuit.
Okay.
I hope I'm as clear as I can on that. Okay. But what Judge Fullerton said is true. I can see the cases, the filing of the cases is still ongoing. It's just the court procedures that will follow. And I suspect that in the months to come, the court procedure, the court room 2003 is going to be crowded. So we will have to follow our safety procedures and improvise, but that has yet to come. But we're very cognizant about the safety of the people that are going to come in the courthouse. Thank you.
Thank you. Mark Husky wrote to the panel, where do we find the email addresses for the judges and the judges' assistants to submit documents, whether they be proposed orders or newly filed motions, anything of the sort? Is there a central place where we can locate all email addresses for the court?
Yeah, and the circuit's website, each courtroom should, I haven't checked it in a while, should have a website that has all that information I don't have the address off the top of my head. I'm sure somebody here has it, but the circuit court's website should have that information for each courtroom and each judge.
Yeah.
All right. Is there anything else? I'm looking through the questions, but is there anything else that our panel of judges would like to inform our members of as we bring the program to a close?
The only thing I guess I would add, it's not really adding, it's echoing what Paul said earlier, is that communication is the key. So if you have questions, you have concerns, let our administrative assistants know. We'll do our best to answer those. And I can't stress this enough. I urge you to communicate amongst yourselves and get those agreed orders if you can, and get those agreed briefing schedules. So communication is the key. It's a challenging time for all of us, and we all have responsibilities, but we also have a responsibility to the legal community to do our best to overcome those challenges, and I'm confident we're going to get that done.
That's well said. We're all going to try and, you know, you understand the goal here is to try and get cases moving again. And this is a method we're going with remotely, electronically, and it's going to be a process.
Many of us attended a webinar given by the Administrative Office of Illinois Courts yesterday with judges all over the state. And what I came away with was, this is really uncharted waters. Nobody in the state knows how to do this. So we're all learning. So attorneys, please be patient with the judges as well.
I would like to say, I know all the judges recognize that this is probably creating a financial hardship on attorneys in private practice. We would be open to hearing suggestions if you think there's some way we could improve this and make it more palatable to attorneys in terms of enabling them to do the work that they need and want to do. So don't be afraid to make suggestions about ways that we might be able to accommodate your ability to do work for your clients and earn your living.
Couldn't agree more than what Brian Diamond just said, because I was a private practitioner for many years. We want to be able to accommodate you and accommodate your clients. Thank you.
And any suggestions for innovative whereas clauses should go to Chief Judge Guerin.
Yes.
So with that, I have one comment. It's not a question, but a comment from one of our members, Amanda Hamilton, and I think it echoes what all of our members feel about our judiciary. She writes, "I am so appreciative that the DuPage Court has taken such initiative and found ways to adapt and utilize the technology we have. I can't wait to get back in the court, even remotely, and to keep our cases moving forward." And I think a lot of us who are always on the second floor feel the same way. We can't wait to get back in the court. We know this is a different way of doing things. This is new to us. This is new to the judiciary. And like Judge Kleeman said, it's all about communication, cooperation, and just trying to keep the cases moving for our clients, for the litigants, and for the court. And we do appreciate everything that the court does to keep our members informed, to give us some direction. And we do appreciate all the time and effort that you spend helping the DCBA and its members with trying to navigate through these tough waters. So thank you very much to all of the judges who have helped us in the program today.
Matt, I'd just like to remind everybody that just because the courthouse is closed doesn't mean that attorneys are not allowed to go out and get a free donut on Thursdays still.
That's noted. Again, thank you to Chief Judge Guerin, to presiding judges Fullerton and Kleeman. Thanks to Judge McCluskey, Judge Schwartz, Judge Whedon, Judge Diamond, Judge Gibson, Judge Orell, and Judge Popejoy. Thank you very much to Robert Rupp, our Executive Director for DCBA, and Barb Mandrala, who have been instrumental in putting the Q&A programs together and helping us advance technologically so that we can keep up to date on all the court procedures and stay in touch with one another. I said at the beginning of this program, this is the first time I've seen all of you in probably 2.5 to 3 months. And it's nice to see familiar faces. And even if it's remotely, like Amanda Hamilton said, at least we're continuing to move along. We're continuing to administer our cases, and we're continuing to help people and stay sane. So thank you very much for all of the things that you're doing as a bench to help our attorneys and our litigants move their cases forward.
Thank you.
Thank you.
Matt.
Thanks a lot, Matt. Thanks to the DCBA.
Thank you.
Thanks.
I do have a few announcements, and for the judges, if you'd like to depart, that's perfectly fine. We do have the installation of President's Ball that was originally scheduled for June 5th has been rescheduled to Friday, September 18th. There will be a small event to recognize the installation of Wendy Muslek as our DCBA president for 2020 to 21 for the officers and for the directors. That'll be a small ceremony in June, but the real shebang is on September 18th of this year. Also, the DuPage Association of Women Lawyers installation that was originally scheduled for May 28th is also postponed and will now take place on September 24th at Arrowhead Golf Club. The DAWL would love to see folks attend that. The 2020 golf outing for DCBA will be Wednesday, August 26th at Naperville Country Club. We're switching the venue this year to a nice country club setting in Naperville. And we hope everyone can attend that. Hopefully by August 26th, everybody will be golfing again. And the DCBA and DAWL will be hosting a joint judicial reception on October 22nd at Donata House. So if you want to say thank you to some of these fine judges that have participated today, you can do so in person on October 22nd at Donata House. That's all we have for today's program for the Civil Law and Practice section. Thanks again to all of our judges. Thanks to all of our members for attending. You can look at the DCBA's website for a recording of this program after tomorrow morning. And we appreciate everybody's time today. Thank you very much.
Thank you.
Thank you, Matt.
Thank you, Matt.
Thank you, Matt.
Take care, everyone.